Yeah, then perhaps we delve into that a bit as well, since it was on the cards that we would have a discussion around issues of conflict of interest, especially when they arise between parties who are not independently represented. Are there scenarios you find in the real estate industry where we see conflicts of interest arising when there is lack of independent legal representation?
Yes. That particular question, in general, it is not unusual to have one advocate represent both parties. Remember, like I've said, in most cases, parties look for advocates after they've negotiated, after they have the terms and conditions, they have the payment plan. So basically, the advocate comes in to do due diligence and to put in writing the terms that these parties have already agreed upon, right? So it's not unusual to have an advocate represent both the buyer and the seller. However, it is not advisable, right? Because remember, when a transaction goes smoothly, then there's nothing to worry about. But please remember, even the simplest conveyancing transaction, the simplest property acquisition can go wrong, right? So in essence, in general, basically, it's not unusual and it is not illegal and it is not, what do we say?
Side of standard
practice to have an advocate represent the two of you. But the only conflict of interest actually arises when there's a dispute. Majorly, it comes in when there's a dispute. In case the transaction goes smoothly, I promise you, you will be well presented, you will get, representation is supposed to. But also remember that this advocate, despite as much as I am advised, or rather it is my profession to become impartial when I'm representing both of you, please remember that an advocate is still human. They can even unconsciously become biased, right, to one particular client. And if in case of a dispute, you will feel the inflicted client will feel the advocate favored the other client, right? But please let us go back to the issue of conflict of interest. Or rather the issue of dispute arising. The courts in many occasions have refused advocates to give evidence in this kind of disputes. So assuming David, your party A, and party B was buying a property and I was the advocate, there is no other advocate. In case a dispute arose between you and party B, in most cases the court has refused an advocate, now me, to give evidence because my evidence would be impartial. If I give evidence against A, it's unfair to B. Yes. It's unfair to you. If I give evidence in favor of B, it's unfair to A. You understand? And in essence, I was supposed to be the middle party. I was supposed to be impartial to the two of you. So there has been precedents that make this practice of having one advocate very, risky, so to speak. I will give you an example of one case. There are so many cases I could quote, so many, but I want to give you a case it's called Francis Mugo versus James Mude. This particular case, the advocate has drafted, I think, a lease agreement, and then there was a dispute. The court decided that the defendant wanted to call the advocate who's drafted the lease as to give witness or rather to give evidence. The court decided no, the advocate, the witness of the evidence of this advocate cannot be impartial because it cannot be used against the other party who also sought their representation. So there are so many cases. So like I said, yes.